And I know Michelle, there's been a lag lately, and when we get this,
Yeah,
when we
that's
start
when
the
we've got
streaming.
the screen share going, which I don't have going now. So you should be good.
Okay, very good. All right. Well, it looks like on my screen it says we are recording and we are streaming. So I am going to convene the hearing. We're now on the record video streaming. I'm calling the hearing to order. My name is Andrew French, Chair of the Kansas Corporation Commission, serving as presiding officer for this hearing, and I'm joined by my fellow commissioner, Annie Keither. These are consolidated dockets 24 CONS 3001 CPEN regarding the status of Thor Operating LLC's license, 24 CONS 3072 CPEN regarding a licensing penalty against Keto Inc., and 24 CONS 3086 CMSC regarding a show cause order against Thor and Keto. The first thing we're going to do is we're going to gather the entries of appearance, and I will start with commission staff.
Good morning, Chair French. Good morning, Commissioner Keither. Kelsey Marsh appearing on behalf of Commission staff and the public generally.
Good morning, Kelsey. And for operator?
Commissioner French, John Horst appearing for past operator, Keto Inc., and new operator, Thor Operating LLC.
Good morning, Mr. Horst.
Morning.
We will now move to notice of this proceeding. Does staff have a recommendation regarding the notice of this hearing?
Yes. Notice of this hearing was contained in the presiding officer's September 23rd order setting an evidentiary hearing in these dockets for Tuesday, October 8th, 2024, beginning at 8:30 a.m. via the Zoom video conferencing platform. Presiding officer's order was properly served on the parties. Additionally, I would note that Keto and Thor and its counsel are in attendance today. Staff recommends that notice is proper and that the commission has the jurisdiction to hear this matter at this time and place.
Are there any objections? Hearing none, I will, and based on staff's recommendation, I will find that notice is proper and the commission has jurisdiction over this proceeding at this time and place. I'll now just do a few preliminary matters, and then we'll discuss the procedure of the hearing. Some of our standard reminders. First, because we're conducting this over Zoom, we know that sometimes things can go wrong. If any party encounters a technical issue, please just ask to go off the record. Then we can recess and resolve that issue, and then we'll go back on the record. Second, witnesses are asked to keep their microphones off or muted when they're not scheduled to talk. If everyone would also mute your cell phones, phones in your offices, other electronic devices, that would be appreciated. Third, so the parties are aware, if the commission needs to consult among ourselves for something like an evidentiary ruling, we'll go off the record and enter into what's called a Zoom breakout room to discuss that, and then we'll return and go back on the record for our ruling. Fourth, please be very careful to identify exactly what you're referring to when discussing pre-filed testimony or exhibits. We should have copies of everything on hand that's been provided to us, and so we should be able to follow along as long as people specifically identify what they're referring to. With that, do the parties have any other preliminary matters they wish to take up? Hearing none, we'll move to the procedure for the hearing. Typically, the parties are going to be allowed to make opening statements. After opening statements, we will have examination of the witnesses. After direct examination of each witness, there will be an opportunity for cross-examination from the other parties. Then there will be commission questions and redirect. Any further examination would be simply at the discretion of the commission. Following witness examination, we will allow closing statements and arrange for the filing of post-hearing briefs if necessary, and then we will conclude the hearing. So, as I said, we're going to start with opening statements. Let's begin with staff first.
Thank you, Chair French. May it please the commission. Today we have 3 dockets that are before you. I'd like to briefly kind of go over the issues in each of the dockets and kind of just lay the table a little bit. First is docket 24 CONS 3001 CPEN. Or I think it's a show cause or CMSC. I probably have the end of that wrong. But either way, the issue before the commission in that docket is whether Thor should continue to have a license. And I guess there's 2 issues. The other issue is whether staff should be required to process the T1 forms between Keto and Thor. I believe that the evidence will show that this transaction hasn't been done at arm's length and that the T1 should be denied and that Thor's license should be rescinded. The second docket is 24 CONS 3072 CPEN. It's a penalty order against Keto Inc. regarding unplugged wells on an expired license. This penalty order is pretty straightforward. The question or the issue is simple. Are there unplugged wells on Keto's expired license? And I believe that the evidence will indicate that there are. The last docket is docket 24 CONS 3086 CMSC. This is a show cause docket or a miscellaneous docket that was issued to both Keto and Thor. The issues in this docket are whether Keto was conducting operations after its license had been expired and revoked, or whether Thor was operating wells that were not on its license. I don't think there's any question that their wells were in operation. I think the evidence will indicate that the wells were under operation under Mr. McCann's direction, and also indicate that Thor continued to operate the wells even though it knew it probably shouldn't be operating those wells. So those are the issues before the commission. Thank you for your time.
Thank you, Mr. Horst.
If it pleases the commission, I generally agree with the description of the issues in the three dockets that are presently before the commission. The legal position of my clients, Keto, Mark McCann, and Thor Operating LLC, Scott Getz, is set forth in the motion for summary judgment that was previously filed in these consolidated dockets. And I won't reiterate that legal argument in great detail. Suffice it to say that my clients submit that it is within the province of the legislature to adopt statutes governing issuance of operators' licenses and the operation of oil and gas wells. The Corporation Commission was created by the legislature to enforce those statutes and adopt regulations for their implementation. The condition which KCC staff asserts disqualifies Thor Operating LLC and Scott Getz from obtaining and maintaining a license and accepting transfer of the wells on the leases in these dockets is that the past operator, Mark McCann, may exercise some degree of control over Scott Getz, who was a prior employee of one of Mr. McCann's companies. Although the issue of control is factually disputed, even if it exists, this is not a condition or relationship which KSA 55-155, particularly subsection C, prohibits. Now, it appears that much of staff's concern relates to its perception of Mr. McCann as an unworthy operator and is based upon perceived past misconduct alleged, which is then attributed to Mr. Getz and Thor, which precludes giving Mr. Getz and Thor Operating a fair opportunity to operate the leases and wells that were transferred to it, and certainly seems to raise due process issues. We hope that the commissioners will keep the rights of Thor Operating and Scott Getz in mind as it listens to the evidence in this case. Thank you.
Thank you, Mr. Horst. With that, we will now move to the examination of witnesses, and we will begin with staff. Staff, you may call your first witness.
Thank you, Chair French. Commission staff calls Director Ryan Hoffman to the stand.
Good morning, Mr. Hoffman. Can I have you raise your right hand so I can swear you in? Do you swear or affirm the testimony you should give today is the truth, the whole truth, and nothing but the truth?
I do.
Go ahead, Mr. Marsh.
Thank you. Please state your full name and work address for the record.
Ryan A. Hoffman, work address is 266 North Main Suite 220, Wichita, Kansas 67202.
Director Hoffman, by whom and in what capacity are you employed?
I'm employed by the Kansas Corporation Commission as the Conservation Division Director.
Are you the same Ryan Hoffman who caused to be filed in this docket rebuttal testimony consisting of 11 pages and 3 exhibits on July 3rd, 2024?
Yes.
Do you have any corrections to make to your testimony?
It's sort of an update, perhaps. On page 3, line 11, the question was if I had ever testified before. At the time we prepared my testimony, I had not, but now I have. So that answer should be a yes. Page 3, line 11.
Okay. Any other corrections to make to your testimony?
None.
Do you swear the answers contained in your pre-filed testimony are true to the best of your knowledge?
Yes.
At this time, staff moves for Mr. Ryan Hoffman's pre-filed testimony and exhibits to be admitted into the formal record.
No
Any
objection.
objections?
No objection.
The reference testimonies will be admitted.
At this time, staff tenders the witness for cross-examination.
All right. Mr. Horst, the witness is yours.
Commissioner French, I'm going to attempt to share my screen if I may.
Yes, go ahead.
Actually, I think that there's we practiced this yesterday. Is my screen now shared to show a copy of KSA 55-155?
I do not see it.
You have a share button at the bottom,
Yes, and
and then you pick what you're trying to share from the options. There, it looks like it's going.
Yep,
Very
we've got it now.
okay. And let me see if I can scroll down just a little ways. Director Hoffman, you're familiar with KSA 55-155, is that correct?
Yes.
And you'll observe that I've highlighted certain language of subsection C4 there.
Yes.
Okay. Do you believe the language of KSA 55-155 C4D that is highlighted is ambiguous?
No.
Are you familiar with the rule of statutory construction that words are to be given their plain meaning?
Yes.
If we look at KSA 55-155 C4B, that addresses the concept of control of an entity by a person serving as an officer, director, partner, or member of an artificial entity who is not qualified to obtain a license. Is that correct?
Yes.
Okay. If we look at KSA 55-155 C4C, that addresses the concept of control of an entity by a person holding an ownership interest of 5% or more of the stock of the applicant who is not qualified to obtain a license, correct?
Yes.
Okay. And if we look at 55-155 C4D, that addresses a person who is related by blood or marriage to a person who's not qualified to obtain a license.
Yes.
Okay. Do you have any facts that indicate that Scott Getz is not qualified under KSA 55-155 subsection C 4 to be issued an operator's license as the sole member and manager of Thor Operating LLC?
Under C4, no. Under C1, potentially. But you asked about C4, so.
Okay. And you're concerned that Mr. Getz has not provided sufficient information for purposes of identification to the commission?
Not as Mr. Getz himself, but as Thor LLC and how it would be different from Keto, how they're different entities. They appear to operate the same exact way.
Mr. Hoffman, is there any express language that you observe in KSA 55-155 beyond what we have just discussed, which addresses the concept of control?
No.
When I review your pre-filed testimony and the pre-filed testimony of other staff, it appears to me that the primary concern that KCC staff raises in this docket is the ability of Mark McCann to control Scott Getz. Is that correct?
Yes.
So beyond the prohibitions of KS 55, 155, C4, B through D, do you find any express language in that statute which disqualifies an applicant based upon whether that applicant is subject to control by a person not qualified to obtain a license?
No.
How is the commission to determine what amount of control is prohibited and what amount is acceptable?
That's an excellent question. I think they almost would have to do it on a case-by-case basis.
Mr. Hoffman, do you believe there is permissible control and impermissible control?
Well, I think that it goes beyond permissible and impermissible control. There's a multitude of factors that are at play in situations such as this, where you have not all of the wells on leases being transferred, not all of the wells on an operator's inventory being transferred. When you have an operator who says, we're only taking the wells that don't have regulatory issues, and the other operator hasn't taken the steps necessary to address the issues that are preventing them from getting a license. I think it's easy to look at the statute in a vacuum and say, well, this is how it should be applied. But the commission has a broader role than merely focusing on the C4.
So what factors is the commission to apply to make the determination of whether there is a level of control that's prohibited?
Well, like I mentioned, I think it would almost come down to fact-specific instances. If this were a different situation, if Mr. McCann had not been revoked, and then within a week, the operator's license shows up, and then only some of the wells come off, there's as Mr. Marsh alluded in his, or not, didn't allude, as he stated in his opening statement, there's a lack of what appears to be an arm's length transaction appearing there, because it all appears as though it's a result of the license revocation, and then only certain wells are being transferred.
Let me see if I can close out of this screen.
There should be a button, Mr. Horst, that says stop share.
Yes, and there we go. Sorry, it's eluding me. Thank you.
There we go.
Here, bear with me. I'm going to have to do it this way. And I apologize for my clumsy.
You're absolutely fine, Mr. Horst.
Okay, I've attempted to share KAR 823136.
We are still seeing sort of your Windows Explorer. You may need to go back into the screen share and share just the PDF.
Oh, it's not it.
I have Mr. Horst's exhibit here if that would be easier.
I'm afraid that.
Here, John Myers here. What I'll do, I'll pull it up so that neither of you have to worry about it. Give me just a moment.
Yeah, let's let John do. What, Mr. Horst, which was the exhibit you were wanting to pull up next?
KAR 823136.
Very good. All right, Mr. Myers is pretty good at running exhibits for folks. We
I
ask him to do it
apologize.
regularly in these meetings.
We actually tried to practice this yesterday afternoon.
All right, looks like he's got it up.
Very
John,
good.
could you zoom out just a little bit? There we go. That looks
There
good.
you go. Okay. And scroll down. And I think I've lost my train of thought. I guess, Mr. Hoffman, my question, it relates to 823136. Do you observe any language in that regulation? Let me start here. That's the basic regulation governing transfer of operator responsibility from a past operator to a new operator. Is that correct?
Yes.
And is there any language in that regulation that indicates that that the past operator must transfer all the wells on a lease to the new operator?
Well, it says they shall furnish a list of all active and inactive wellbores on the lease within the notice of the transfer.
Yes. It does say that, but does it direct the past operator to transfer all the wells to the new operator?
This specific regulation, no, it does not.
Okay. Is there another regulation that you're aware of that requires that?
Well, it would be more in terms of enforcement of our underground injection control regulations. If the wells aren't transferred, then we would have issues with unplugged wellbores potentially within the area of review.
Yes.
And that would create problems about whether or not wells or injection authority could be transferred. So that is one area.
And I think I can get into that in more detail with Mr. Russell. Okay. I think that's all the questions I have of this witness at the present time. Thank you, Mr. Hoffman.
Thank you.
All right. Well, we will then move to questions from the commissioners. Commissioner Keither, do you have any questions?
No.
Let me see. Mr. Hoffman, I've got a lot of questions, but I think they're mostly of legal nature and probably more appropriate for us just to look at the briefing. Maybe one question, and you can tell me if another staff member is better to address this, but I know in reading the pre-filed testimony that one of the items staff took issue with was the operating agreement between Keto and Thor, and the level of control. It would give the former operator over the new operator. Do you, how familiar are you with operating agreements? Is this the only one you've ever looked at? Have you looked at other operating agreements, yeah, in the industry? Can you give me some idea of the number that you've seen?
I would say that it's probably around 10. It's not something that I would frequently look at. And as you stated, yeah, we do have concerns about the level of control, but it goes beyond just the level of control, and it's the potential consequences of allowing this to happen based on the confines of that agreement. If you like, I could point to those sections of the agreement and explain why we
Sure.
have those concerns. Well, I'll go to my exhibit. It is exhibit just RH1, and then the first page of RH1. When you start looking at what happens going forward if Thor is allowed to operate these, number 4, well, even before we get to number 4, number 3 says that Thor as the operator has full control, but the very last sentence says that they're not liable as the operator. And then if you look at number 4, it says that it's only good for a year, and then it's on a month-to-month basis after that. And reading further, number 6 says that Thor could terminate its legal existence or no longer be capable of serving or fails, refuses to carry out its duties, then they may be removed by affirmative vote of the majority of the owners of the working interest of the leases. Well, that's Mark McCann. There's no one else. That's the evidence shows that. So Mark McCann has sole control over whether or not Mr. Getz remains as the operator. And 7, he gets to pick who the replacement operator is. So if this were to play out, we could see the situation happen over and over again, where as the leases deteriorate and the production deteriorates, Mr. McCann could have one of his friends or former employees prop up a company, operate it until certain wells are no longer good, then transfer the good ones to a new license the same way. And in my testimony, I talk about the testimony of Bill Bryson when this was going on, and he explained this was the exact situation we were trying to stop, was operators basically removing their liability by creating a new entity and just moving on down the line. And so that's why the way this is structured, it gives us great concern.
Is this a standard operating agreement, or does it appear to be different than other operating agreements you've seen, or have you not seen enough to be able to speak to that?
Most of I'm like I admit, I am no expert. Most of the ones that I have seen, there's more skin in the game, if you will, from the person who's the operator. They have some working interest or something else. But again, like I said, I'm not an expert. I can't say that I've read hundreds of them. I'm sure Mr. Horst has seen many more than I have.
That's fair. You're just testifying to how the terms of this agreement apply in this case. That's fair. All right, I think I'll refrain from asking you any statutory construction questions or regulations. I'll confer with my own counsel on that. So I don't believe I have any more questions for you, Mr. Hoffman. Mr. Marsh, do you have any redirect?
A few questions, if I may.
Go ahead.
Director Hoffman, I know Mr. Horst talked to you about 55-155, and you mentioned 55-155C1. Can you see that 55-155? Okay. And that statute talks about, no real application or renewal application shall be approved until the applicant has provided sufficient information as required by the commission for purposes of identification. In your opinion, has Thor provided sufficient information indicating it's any different from Keto Inc.?
No, based on the text messages, they appear to be working just as they were before. The only way they're different is there's less wells.
And does the commission have authority over oil and gas matters?
Yes, under 74-623, the commission has exclusive jurisdiction over oil and gas.
And does that include, jurisdiction over licensing of operators?
Well, I think the statute specifically talks to exploration and production activities, but none of those things are something an operator can do without a license. So, yes.
And I want to transition over to 55 or 8, excuse me, KAR 82.3.136. Can you see that regulation?
Yes.
Okay. I know 82-3-136A talks about the report being upon a form prescribed by the commission. To you, does that indicate that staff has the ability to review the forms and not just rubber stamp them?
Absolutely.
Thank you. I don't have any other questions.
All right, thank you, Mr. Marsh. With that, I don't believe we tread a lot of new ground there, so I think we're gonna wrap up with Mr. Hoffman. Mr. Hoffman, we thank you for your testimony, and you may, Mr. Horst.
Commissioner French, if I may ask some follow-up questions of Mr. Hoffman on his testimony concerning the operating agreement.
Sure, that was a new line of questioning. Go ahead.
Thank you. Mr. Hoffman, who is the operating agreement between?
Kansas Production Company and Thor.
Okay. And on page 4 of the operating agreement, it's executed by Mark McCann as president of Kansas Production Company, Inc. Is that correct?
Correct.
And by Scott Getz as managing member of Thor Operating LLC?
Correct.
Correct. Does the owner of the working interest in an oil and gas lease have the responsibility for paying the costs of operation?
Their proportionate share, yes.
Yes, right. Well, if the working interest owner owns 100% of the operating interest, that would require the working interest owner to pay 100% of the operating costs, correct?
Correct, which is why this is basically Mark McCann operating.
Okay.
He's paying for everything.
Okay. Now, if we look at paragraph 3 of the operating agreement, doesn't the language of the last sentence say that Thor shall operate or conduct all such operations in a good and workmanlike manner?
Yes.
But it shall have no liability as operator to the other parties, which would be Kansas Production Company, Inc., for losses and liabilities incurred, except such as may result from its gross negligence or willful conduct.
That's what it says. But
And are you, Mr. Hoffman, are you implying that that language then would relieve Thor of its statutory obligation to operate the wells in compliance with the statutes and regulations of the Kansas Corporation Commission?
no, I'm not implying that.
Okay. During the period of time that Thor operated the wells on these leases physically, are you aware of any, other than the allegation in docket number 24-3086 that it operated without a license, are you aware of any specific violations of the statutes, rules, or regulations that are currently alleged that Thor committed?
Well, we talked about 136, and if they got the July 3rd notification that we had not processed the transfers yet, then they should have known that they were not in compliance with 82.3.136, that the forms hadn't been processed. And that staff was asking that they not be put on their license, yet they continued to operate those wells. Either they continued to operate them or Keto did. So yes, that would be the violation.
And it's your position, Mr. Hoffman, that 82.3.136 provides notice to Thor that even though the transfer of operator responsibility forms have been submitted, it should cease operation if they haven't been approved administratively by commission staff.
Well, I think that what it should have done is triggered a phone call or a question of what should we do? We've received this. Are we supposed to stop operating? Because those wells were supposed to be shut in under the prior order against keto. So they should have at some point realized maybe something here is amiss. We should check to make sure that everything is fine. Because if those wells haven't been transferred, they're not on their license. They don't have the authority to operate them because they're not on their license. So we could be talking about a 120 violation as well.
I think that's all the questions I have of Mr. Hoffman.
All right. Did that prompt any additional commissioner questions, Commissioner Keither? Okay. Mr. Marsh, any necessary redirect? Redirect?
No, Chair French.
Okay. All right. With that, Mr. Hoffman, you may virtually step down.
Thank you.
Staff, you may call your next witness.
Thank you. Commission staff calls Troy Russell.
Good morning, Mr. Russell.
Good morning.
If I could have you raise your right hand, do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
All right. Mr. Marsh, you may continue.
Thank you. Please state your full name and work address for the record.
Troy Russell. Work address is, let me get here. Chanute District Office, 137 West 21st Street, Chanute, Kansas 66720.
Mr. Russell, by whom and what capacity are you employed?
By the Kansas Corporation Commission Conservation Division as a district supervisor and professional geologist.
Are you the same Troy Russell who caused to be filed in this docket direct testimony consisting of 7 pages and 5 exhibits on May 17th, 2024, and rebuttal testimony consisting of 11 pages and 5 exhibits on July 3rd, 2024?
Yes.
Do you have any corrections to make to your testimony?
No, sir.
Do you swear the answers contained in your pre-filed testimony are true to the best of your knowledge?
Yes.
At this time, staff moves for Mr. Troy Russell's pre-filed testimony and exhibits to be admitted into the formal record.
No objection.
Hearing no objection, the reference testimonies will be admitted.
Thank you. Staff tenders a witness for cross-examination.
All right. Mr. Horst, the witness is yours.
Thank you. Mr. Russell, in your pre-filed direct and rebuttal testimony, you indicated that there were wells that were on the transfer of operator responsibility form that were enhanced oil recovery wells, and you raised concerns about the concept of area of influence, the quarter-mile area around the radius of those wells. Do you recall that testimony?
Yeah, in general, if you wanted to specify that in the testimony, that'd be good. But yes, in general.
Well, I think without specifying that in the testimony, let's start here. Is it correct that the concept of the 1/4 mile area of radius is a presumption that saltwater, I'll use layman's terms here, salt water that's injected into an enhanced oil recovery well may travel in any distance within a quarter mile radius of the well bore. Is that the basic presumption underlying the area of influence?
I would add to that the concern is that we would have what the corporation gives a status of inactive well, or well that does not have an operator, that we do not want abandoned wells within that quarter mile area of review because of the potential for negative impacts to surface or groundwaters. Yes.
Okay. So, but in other words, there is a presumption that that the salt water that's injected may migrate to an abandoned well within that quarter mile radius area, correct?
Yeah, the communication with that.
Right. And that presumption is applied without respect to the practical, what actual facts may exist in a particular situation. For example, if there's a production well between the enhanced recovery injection well and the abandoned well, that's not a factor that that commission staff takes into consideration. Is that correct?
Could you repeat that? I'm sorry.
Okay. My question is, do any practical on the ground aspects of the operation influence the analysis of the area of the quarter mile radius area of influence? I'm not asking that.
I think I understand. I will try to give you an answer here. The first thing that would be done once a well has been identified as being that we have an inactive or an abandoned well within an area review of a UIC well, is then we would start making our determination of the construction of that well, what the casing integrity may be of that well, what options are available to eliminate any threat that well may possibly cause from the subject UIC well operations of.
So if there are practical factors such as the existence of production wells that may be between the abandoned well and the injection well, or a number of production wells that may be withdrawing more fluid than is being re-injected into the formation, how does that apply to the area of influence analysis?
If the wells that you're talking about, if they're in production and producing and are on an active license, and we have no information of concern that we may have any kind of casing failure with those wells, those are not at issue. It's simply the abandoned or inactive wells that we would take issue with the AOR. Once we have that, then we would begin and take in all influences, but that inactive or abandoned well, it has to be addressed. It'll have to either be put on an operator's inventory, obtain an approved TA once that's done, or casing integrity tests for TAs if applicable, or return to service or plugged.
Mr. Russell, I believe the records in this case reflect that the T1 transfer of operator forms from Keto Inc. to Thor Operating LLC were submitted to the KCC between late March 2023 and early May 2023. Do you agree with that general time parameter?
For the Appleby, DeArmond, Flossie White, and the McFarland, Morton, and Sears, I believe we touched on that was early April to early May of 2023.
Okay. And when was Thor or Scott Getz first notified that the transfer was not administratively approved?
That wouldn't have came out of the district office. That would have come out of the central office. So I don't know that exact date.
And do you know in what form that notice was given to Thor or Mr. Getz?
No, that would be a question for other staff today, Nancy or Denise, as far as if it was a letter generated or electronic submission.
Do you know how Thor or Scott Getz were notified that operation of any of the enhanced oil recovery wells would violate or potentially violate 82.3.120 and 82.3.133?
How they would have had knowledge of that?
Yeah, how was Thor notified of that potential violation?
I would concur with, what Director Hoffman touched on. They should have seen that those T1s had not been processed and that he should have been making some calls.
But my question is, was notice given in writing to your knowledge, was notice given in writing to Thor or Mr. Getz that it was operating these wells in violation of 82.3.120 or any other statute of regulation?
Objection. Hasn't this already been asked and answered?
I don't believe that he answered whether there was notice given in writing or by other means.
Well, he said that would be a better question for other staff.
I'll let him answer it one more time.
Okay.
The district does not send such notices. They would have come from the central office.
And Mr. Russell, are you aware of any notices given to Thor or Scott Getz of any violations of KAR 82.3.111, the temporary abandonment regulation?
I believe that if they had filed, whether on paper, they can't, if Quito filed them on paper while their license was revoked, that's an automatic denial of the TA form because you have to be have an active license to file a TA. I'm not aware of any TA form submitted by Mr. Getz on Kohler. If he had and they were denied, then they would get a NOV generating the reasons why they were denied.
So to your knowledge, no notice was given to Thor or Getz of 82.3.111 violation?
Well, I believe if we ask, again, we'll have other commission staff that's familiar. If they were filed on Kohler, they would have got notice. If they were filed on paper, they would have been processed via paper. And if they were denied, they would have got notice.
Mr. Russell, what action does the commission staff typically take when apparent violations of the statutes or regulations governing oil operations are observed in the field?
What? Will you repeat that last part, please?
What action does the commission staff, you supervise a number of employees at the District 3 office in Chanute, is that correct?
Yes, sir.
Yes. And included in the staff that you supervise are folks that are out in the field conducting inspections of oil and gas operations on a daily basis?
Yes, sir.
And what action does the commission staff then typically take when an apparent violation of the statutes or regulations governing oil operations are observed by the members of your staff?
Yeah, if staff observes in general any violation, they will notify verbally that operator if they can get a hold of them. They'll document that in field reports or whatever documentation is required, spill complaint such as that. And then if necessary and it's not resolved, then NOVs will be sent for that. Now, in that aspect, if they are out doing inspections to check compliance with a commission order, then they're going to report back to me, and we'll report that to legal staff to inform them that whether a commission order has been adhered to or not. So you kind of have two different areas you're going there.
So under the facts of the present case, the inspection by Mr. Triboulet of the Sears number 30 well in July of 2023, was that at the direction of legal staff?
No, as at the district's direction through the compliance officer, it is common that once a commission order has been made and the timeframes involved, then that we will do an inspection to see if those orders have been adhered to.
And so my question,
If during that process, they come across, say, a spill or something like that, they'll notify the operator of that spill. They don't ignore it.
so the docket that one of the dockets that we're involved with in this case, 24-3086, asserts that Thor operated wells without a license. You're familiar with the assertion in 24-3086?
Yeah, Thor operating wells that weren't on their license.
Yes.
Yes.
And when Mr. Triboulet observed the Sears 30 well being operated in July of 2023, how was Thor operating, or Scott gets notified of that fact?
Well, John, can you pull up Thad's, I don't know, have that field report?
It's attached to Mr. Triboulet's. No, it's attached to the, and I cannot, it's
Yeah.
attached.
I have it. Mr. Getz would have been notified, I believe, verbally.
Do you know who notified Mr. Getz verbally?
I do not, because I don't know who ceased operations on it. So somehow when they shut that well in, somebody had notified them.
Do you know when that well was shut in?
No, I do not. Because when we would come back, we reported it to legal staff, and then I assume legal staff would have made the contacts to Mark and or Scott.
Mr. Russell, on page 6 of your pre-filed rebuttal testimony filed on July 3rd, 2024, lines 14 and 15, you testify that District 3 staff sealed the Sears lease on October 10, 2023.
Correct.
And is it your testimony that prior to that date, Mr. Getz or Thor, excuse me, let me rephrase that. Is it your testimony that prior to that date, Mr. Getz had been notified to cease operating the Sears number sign 30 well?
It would be my testimony that I would assume he would have been either by verbally from Pat or Ryan Doolin or from legal staff.
Okay. Mr. Russell, are you familiar with compliance agreements?
Yes, sir.
Are compliance agreements a tool employed by the District 3 office to assist operators in achieving compliance with the statutes, rules, and regulations governing oil and gas operations?
Objection. What's the relevance?
The relevance is whether Keto Inc. has been offered an opportunity to participate or engage in a compliance agreement, and what the criteria for eligibility is.
I'm not sure how that's relevant to the issues that we have before the commission today.
Mr. Horst, restate that question for me one more time. I'm not sure I caught the whole thing
Okay.
before I make a ruling.
My question is, my question to Mr. Russell is, what are the criteria determining eligibility for a compliance agreement? And I may have skipped. My preliminary question was, are compliance agreements used to assist operators in achieving compliance with the statutes, rules, and regulations of the commission?
I'm having a hard time with the relevance here to the particular facts of this case. I mean, you're asking Mr. Russell essentially how settlement agreements are negotiated.
Let me attack it a different.
Okay. If you can rephrase, and then I'll probably let Mr. Russell answer it to the best of his ability. I hate to, I want to give some latitude, but I'm having trouble seeing how it's going to help us here.
Mr. Russell, on page 10 of your pre-filed rebuttal testimony filed on July 3rd, 2024, you're asked to ask a question that pertaining to Mr. McCann's testimony. He states that Keto desires to comply with KAR 823111, and you're asked if you believe that statement is accurate based upon your experience with Keto, and your answer is, I do not. And you indicate that Keto has demonstrated in the past a willingness to make expedient corrections to shut-in dates, fluid levels, move equipment from well to well for short-term operations, and fail to report or act on spills unless field staff discovers them or landowners report them. Do you see that testimony?
Yes,
Okay. So then the next question is, given the operating agreement between, oh, excuse me. Let me back up here. So again, my question is, if Mr. McCann states that, well, let me go a different direction. The issue with respect to the temporary abandonment regulation is that an operator has a situation where there are multiple wells on its license that are not fully equipped and either need to be plugged, returned to service, or temporarily abandoned. Is that generally what 82.3.111 addresses?
yeah, that's what 82.3.111 addresses.
And compliance agreements are designed to assist operators in achieving compliance with 82.3.111. Is that correct?
Not just 82.3.111, but yes.
Okay, among other issues,
Yes,
but
sir.
82.3.111 would be an issue. And is it correct that there are other operators in District 3, Southeast Eastern Kansas, that have problems with temporarily abandoned wells on their operator's license?
Correct.
Okay. And has District 3 recommended compliance agreements for other operators in your area?
Objection,
those
real
who have-
events. I don't know what compliance agreements for other operators has to do with Keto Thor, the issues that are before the commission today.
And again, Commissioner French, we're simply trying to point out that Keto's expressed a willingness to try and cooperate with and work with the commission in District 3, but it has been refused that opportunity.
I'll let Mr. Russell answer to the extent he can. If you'd repeat the question for him.
Okay. Are there other operators in District 3 that have entered into compliance agreements, Mr. Russell?
Yes,
And some of those compliance agreements have addressed temporarily abandoned wells on those operators' licenses.
correct.
And do you have any idea how many such compliance agreements have been entered into in the past 5 years?
I don't know, entered into, but I think we have approximately, and this is in general, but close to 20 agreements.
Okay. And what are the criteria for determining whether an operator qualifies to be considered for a compliance agreement?
That they have demonstrated with their record in the past, the willingness to comply and to be good faith in the negotiation of these said deals. And even though I see where that has been stated that they desire to, it has not been demonstrated by action at all.
And is that criteria reduced to writing somewhere that you're aware of, Mr. Russell?
No, we use that at the district office when we do, because generally we approach or they approach, oftentimes we may approach some or they approach us, and then we'll go from there.
So is it correct that although Keto and Mr. McCann have made verbal and written requests to participate in compliance agreements, their requests have been declined?
I have not seen a written request at all.
I don't think I have any further questions of Mr. Russell. Thank you.
All right. Are there any commissioner questions for Mr. Russell? Commissioner Keither, do you have any questions? I'm seeing a head shake. I also do not have any questions for you, Mr. Russell. Mr. Marsh, do you have any redirect?
A few redirect questions, if I may.
Sure.
Mr. Russell, did you attach production records to your testimony?
Yes,
I'm going to share my screen real quick. Mr. Russell, can you see production records for the Sears lease?
yes,
Okay. I'm going to scroll down to page 18 of 22 of what's been marked as exhibit TR-2. There were reported sales for the Sears lease in February of 23, March of 23, and April of 23. Would you consider that to be constant production across those months?
it would support that assumption, especially when taken into consideration with the U3Cs that were filed.
Okay, thank you. I know Mr. Horse asked you several questions about 82.3.111. Does district staff typically send notice of violations letters to operators who don't have any wells on their license?
No,
And then I know that Mr. Horse went into some detail about compliance agreements and described Mr. McCann's willingness to enter into a compliance agreement. Do you think that willingness to comply with the commission regulations is genuine?
no.
All right, thank you. No further questions.
All right. We have come to the conclusion of all Mr. Russell's testimony. If there's nothing further for this witness, Mr. Russell, you may step down.
Thank you.
Staff, you may call your next witness.
Thank you. Commission staff will call Thad Triboulet. And while he's getting seated, can we change Troy Russell's name to Thad's, please? Thank you.
And just so everyone knows, we've been going a little over an hour. I anticipate giving everybody a short break after this next witness.
Okay, thank you.
And maybe John can fix, yep, he's got it.
All right, Mr. Triboulet, I'm going to swear you in. If you'd please raise your right hand. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Marsh, you may proceed.
Thank you, Chair. Please state your full name and work address for the record.
Thad Triboulet, 137 East 21st Street, Chinook, Kansas, 66720.
Mr. Triboulet, by whom and what capacity are you employed?
I'm employed by the Kansas Corporation Commission, Conservation Division, District 3, Chinook, Kansas.
Are you the same Thad Triboulet who caused to be filed in these dockets testimony consisting of 4 pages and 1 exhibit on May 17th, 2024?
That is correct.
Do you have any corrections to make to your testimony?
No, I do not.
Do you swear the answers contained in your pre-filed testimony are true to the best of your knowledge?
I do.
At this time, staff moves for Mr. Thad Triboulet's pre-filed testimony and exhibit to be admitted into the formal record.
No objection.
Hearing no objection, the reference testimony is admitted.
Thank you. At this time, staff tenders the witness for cross-examination.
All right, Mr. Horst, the witness is yours.
Mr. Triboulet, I'm going to need to see if I can share my screen again.
Mr. Horace, John Myers here. I can pull that up if you'd like me to.
Okay, I'm trying to pull up application denying letter PDF.
Yep, got it.
Okay, thank you.
You'll probably need to stop.
Mr. Horace, is that what you're looking for?
It is. And if we could, oh, let me see if I can. I don't know if I can manipulate this on my end.
No, you can't. Tell me where you'd like it to be.
That's fine. Okay. Mr. AAA, do you see this temporary abandonment denied letter that you sent to Keto Inc. on the Tom Appleby #2 well?
I'm going to object here just because I believe this is outside the scope of Mr. AAA's testimony. Mr. AAA's testimony just focuses on the well they found in production on the Sears lease. I'm pretty sure it does.
In response, Mr. Horst?
I don't disagree with Mr. Marsh's comment concerning the scope of Mr. AAA's testimony. No.
All right, so
he's simply the logical witness to testify to correspondence on the Appleby #2 well.
can you tell me why he's the logical witness if it wasn't in his testimony?
Because correspondence from the current operator was directed back to Mr. AAA, but we've got no response to it.
Well, I'll let you go ahead and ask your question because I don't think you've asked anything other than whether he sees the document. I'll go ahead and let you ask a couple questions. If the witness has knowledge of it, we'll let him answer to the best he can.
Okay.
But we're obviously going a little outside the scope here.
I understand. I'll try and keep it limited. My question, Mr. AAA, is this is a letter that you apparently sent to Keto Inc. concerning denial of a temporary abandonment application on the Appleby #2 well, correct?
That is correct.
Mr. Myers, if we can pull up the other exhibit, which is a letter back to
Yeah.
Mr. AAA.
Yes, one moment. Is this the document, Mr.
It
Horst?
is. And I believe that Mr. AAA, do you recall receiving this letter from Thor Operating shortly after March 10, 2024, which addresses its assertion that the Appleby #2 well was actually in operation in 2017?
It's been a few months ago. I do not recall actually reading this letter at the moment.
So you don't know whether a response has been provided to Mr. Getz or Thor with respect to the matters that are addressed in this March 10 letter, is that correct?
Well, this letter here is from Thor Operating.
Correct.
Yeah, and as far as I'm understood, Quito Inc. was revoked from a license from his license. And as far as I know, there wasn't any T1s that were transferred into Thor operating. And so as far as you're wanting to know, I just don't see that how this letter is relevant to the Appleby well when Thor operating is not the operator of this well.
So my final question is, was a response given either to Mr. Getz and Thor or to Mr. McCann and Keto with respect to this letter?
Well, do you have a CP 111 temporary abandonment form for this well that's been documented by me in an exhibit?
It was what your TA denial in the first letter addressed.
Okay.
Okay.
And it was denied, is that correct?
That's
Mr.
correct.
Wilbur? Okay.
So you don't know whether there was any response given to this letter?
No, I do not.
Okay, that's all the questions I have of Mr. Triboulet. Thank you.
Thank you. We will now move to commissioner questions. Commissioner Keither, any questions for this witness? Looks like a no. I have no questions for you, Mr. Triboulet. Mr. Marsh, any redirect?
No redirect.
All right. Mr. Triboulet, you may step down. Thank you for your testimony. Let's see. Yeah, we've still got several staff witnesses. Let's go ahead and take let's do a 10-minute break. We will come back at 10 a.m. and resume with staff's next witness. So at this time, we are off the record and in recess. We will return at 10 a.m.
And I believe staff's next witness is going to be Dwayne Sims. So if we can go ahead and change and update the name, that would be great. Thank you.
We are in recess. All right, I have 10 a.m. Looks like we have everybody we need to continue examination. So we are now back on the record in this evidentiary hearing, and we are ready for staff to call its next witness.
Thank you. Commission staff calls Dwayne Sims.
Good morning, Mr. Sims.
Morning, Mr. French.
Would you please raise your right hand? Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Marsh, you may continue.
Thank you. Please state your full name and work address for the record.
Dwayne Sims, 137 East 21st Street, Chinook, Kansas, 66720.
Mr. Sims, by whom and what capacity are you employed?
I'm employed by the Kansas Corporation Division. I'm employed by the Conservation Division of the Kansas Corporation Commission as the manager of the Underground Injection Control Program and an environmental complimentary and regulatory specialist.
Are you the same Dwayne Sims who caused to be filed in this docket testimony consisting of 5 pages and 2 exhibits on May 17th, 2024?
I am.
Do you have any corrections to make to your testimony?
No.
Do you swear the answers contained in your pre-filed testimony are true to the best of your knowledge?
I do.
Thank you. At this time, staff moves for Mr. Dwayne Sims' pre-filed testimony and exhibits to be admitted into the formal record.
Hearing no objection, the reference testimony will be admitted.
Thank you. At this time, staff tenders the witness for cross-examination. And Mr. Horst, your mic is still muted.
Mr. Horst, the witness is yours.
Can you hear me now?
Yes, we can.
Thank you. Good morning, Mr. Sims.
Good morning, Mr. Horst.
On your exhibit DS1, pages 2 of 5, 3 of 5, and 4 of 5, and I believe 5 of 5, involve MIT tests that were conducted back in, I believe they're all in 2020, and indicate that they were witnessed by Scott Getz, and his title was Pumper at that time for Keto Inc.
They are not MIT tests. They are case and integrity tests, which
Sorry. I
is tied to
apologize.
an oil well. But yes, he did sign them as pumper and witnessed. He was the witness, the operator's witness at site.
Then on pages 8 of 16 through 16 of 16 of exhibit DS2, these are case and mechanical integrity tests. Performed on various dates in 2023 and 2024. And are these forms that are generated by commission staff and filed?
Yes, they are.
Yes. And on these forms, Keto Inc. is still listed as the operator, but Mr. Getz is titled as a manager or supervisor on those forms. Is that correct?
Yes, it is.
So does that recognize a difference in Mr. Getz' status by field staff?
I did not fill these forms out. They were filled out by Thad AAA. I don't know what the status of that is. I don't know what he classified himself as at that time. I was not in contact with Scott Getz.
I think that's all the questions I have of this witness.
All right. Any commissioner questions? I don't have any for you, Mr. Sims. Commissioner Keither, do you have any questions? And Mr. Marsh, any redirect?
I do not have any redirect.
All right. With that, Mr. Sims, I believe you may step down. Thank you for your testimony.
Thank you.
All right, staff, you may call your next witness.
Thank you. Commission staff calls Nancy Borst.
All right, good morning, Ms. Borst.
Good morning, Chair French.
If you would please raise your right hand for me. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Marsh?
Thank you. Please state your full name and work address for the record.
Nancy D. Borst, 266 North Main, Suite 220 in Wichita.
And Ms. Borst, by whom and in what capacity are you employed?
I'm employed by the Kansas Corporation Commission Conservation Division as an administrative specialist.
Are you the same Nancy Borst who caused to be filed in these dockets testimony consisting of 6 pages and 2 exhibits on May 17th, 2024?
I am.
Do you have any corrections to make to your testimony?
I do not.
Do you swear the answers contained in your pre-file testimony are true to the best of your knowledge?
Yes.
At this time, staff moves for Ms. Nancy Borst's pre-file testimony and exhibits to be admitted into the formal record.
No objection.
Hearing no objection, the reference testimony will be admitted.
Thank you. Commission staff tenders the witness for cross-examination.
All right, thank you. Mr. Horst, the witness is yours.
Thank you. Ms. Borst, are you familiar with the proceedings in docket number 22 CONS 3115 CMSC applying to the non-renewal of the operator's license of Keto Inc.?
I am.
Okay. Did Keto Inc. seek to have its license renewed in that case?
Keto submitted a license renewal application June 1st of 2020. At that time, the license was suspended in a couple of dockets, and that precipitated the 22-3115 CMIS docket.
And that in that docket, the commission issued an order initially denying renewal of Keto's license. Is that correct?
Correct.
And did Keto appeal the non-renewal of its license?
It did.
Okay. And was a hearing on that matter conducted on or about December 19, 2022?
I believe it was.
And did that hearing result in a denial of renewal of Keto's license on February 9, 2023?
It did.
Did the effect of the commission's denial of Keto's license renewal prevent Keto Inc. from applying for a new license for 1 year?
It did.
How was Keto Inc. expected to maintain a current license under those circumstances?
It was not a current license. It did not have a current license during that time.
Correct. So if we can now pull up KAR 82-3-120.
I can do that for you, Mr. Horst. One moment. Mr. Horst, it took me longer than I anticipated. I've pulled it up, not on the document that you shared, but on the Conservation Division regs through our website. Is that acceptable?
That is acceptable.
All right. Sorry about that.
Ms. Borst, can you direct my attention to the language in KAR 82-3-120, which provides that it is a violation of that regulation to have wells on an operator's expired license.
82.3.120 deals with licensing requirements. I don't know that it deals with penalties for unplugged wells on an expired license.
Is there another regulation that I should be referring to?
I believe that would be 82.3.133.
So could we, Mr. Myers, could we pull up 82.3.133? And that was not in my documents.
Here it is.
Okay. And can we enlarge that just a little bit?
Does that look acceptable, Mr. Horst?
Yes. So, Ms. Borst, what is the language in 82.3.133 that requires an operator whose license has been non-renewed, that penalizes an operator whose license has been non-renewed from having wells still on that license?
This actually deals with operation of wells in violation of commission regulations. I'd like to
Yes.
back up if I could to 82.3.120A1. I misspoke
Yes,
earlier.
that's what I thought. Okay.
Yeah.
Let's go back to that.
And that says that no operator shall undertake any of the following without first obtaining or renewing a license: drilling, completing, servicing, plugging, or operating any oil, gas injection, or monitoring well. And it goes on to say that anyone who's in physical control of a well or gas storage facility shall maintain a current license, even if the well or storage facility is shut in or idle.
And again, my question to you there was, with respect to that specific language, how was Keto Inc. expected to maintain a license and comply with that provision when the commission had denied renewal of its license?
It could have transferred the wells to another licensed operator.
And in this case, Keto Inc. attempted to transfer some of the wells to Thor Operating LLC, but that transfer has not been administratively approved. Is that correct?
That's my understanding.
Okay. All right. Let me turn to another topic. Ms. Borst, after receiving the letter of credit from Thor, or excuse me, credit for Thor from Stride Bank, did you or someone at the KCC staff notify Thor Operating LLC or Scott Getz of the deficiencies listed in your pre-filed testimony?
I did not.
Okay. Do you know when these matters were first called to the attention of Thor Operating LLC or Scott Getz?
I do not. I took this letter of credit to legal staff and was told because of the ongoing matters to just hold it for the time being. And so that's what I did.
Do you have any information which would indicate that Thor Operating LLC or Scott Getz were notified at any time prior to their receipt of your brief filed testimony on May 17, 2024 of the deficiencies that you'd identified in your pre-filed testimony on their letter of credit?
I do have one indication, and that would be in their license renewal application, which was submitted March 21st. Mr. Getz included a note that he would be mailing a cashier's check. The only reason he would be mailing a cashier's check at that point would be for financial assurance. And if his letter of credit was valid, he would not need to do that. So I don't know if he was concerned that his letter wasn't valid at that point. We never received a check from him, but the system would not have asked him for assurance because his license had no wells.
Very good. I think that's all the questions I have of this witness.
All right, thank you. Any commissioner questions for Ms. Borst? Commissioner Keither?
No, thank you.
And I have no questions either. Mr. Marsh, any redirect?
Yes, please.
Go ahead.
Ms. Borst, does Keto have a current license?
No, it does not.
Are there unplugged wells remaining on that license?
There are.
I know Mr. Horst talked about, or maybe you mentioned that something about a cashier's check from Thor. Did staff ever receive such a check?
No, we did not.
I believe that Mr. Getz in his testimony stated that Thor would pay $1,800 in financial assurance. Has that been done?
No, it has not.
And I know that Mr. Horst also discussed a letter of credit, whether any notice was sent to Thor regarding its insufficiencies. In your opinion, should an operator expect a letter of credit that does not conform with the commission's instructions to be acceptable?
No.
Okay, thank you. No further questions.
All right, thank you. We have come to the conclusion of your testimony today, Ms. Borst. You may step down.
Thank you.
We will now have staff call its final witness.
Thank you. Commission staff calls Denise Klug.
Good morning, Ms. Klug.
Good morning, Commissioner
Okay.
French.
I will now swear you in. If you would please raise your right hand. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Marsh, you may proceed.
Thank you. Please state your full name and work address for the record.
Denise Klug, 266 North Main Street, Suite 220, Wichita, Kansas, 67202.
And Ms. Klug, by whom and in what capacity are you employed?
By the Kansas Corporation Commission, Conservation Division, Central Office, and I'm the program specialist and the Kohler lead.
And are you the same Denise Klug who caused to be filed in these dockets testimony consisting of 5 pages and 3 exhibits on May 17th, 2024?
I am.
Do you have any corrections to make to your testimony?
I do have an update on page 2, question 17. Have you previously testified before this commission? On May 17th, I had not, but since then I have.
And do you have any other corrections to make to your testimony?
No.
Do you swear the answers contained in your pre-filed testimony are true to the best of your knowledge?
Yes.
At this time, staff moves for Ms. Denise Klug's pre-filed testimony and exhibits to be admitted into the formal record.
No objection.
Hearing no objection, the reference testimony is admitted.
Thank you. At this time, staff tenders the witness for cross-examination.
All right. Mr. Horst, any questions for this witness?
Commissioner French, I don't believe I have any questions for this witness.
Okay. Are there any questions from the commissioners?
No.
I have no questions as well. So I don't believe, Mr. Marsh, you will need to do any redirect. Ms. Klug, yeah, thank you for appearing. We do thank you for your testimony. You may step down.
Thank you.
All right. We have completed all of staff's witnesses. Looks like we are ready for operator to call its witnesses. So, Mr. Horst, you may call your first witness.
Call Mark W. McCann.
Good morning, Mr. McCann. You're on mute. You're going to have to unmute yourself. There you go.
Yeah.
Good morning. I'm going to swear you in. If you would please raise your right hand. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Horst, you may proceed.
Are you the same Mark W. McCann who filed pre-filed direct and rebuttal testimony in these dockets on June 7, 2024?
Yes,
And Mr. McCann, have you had an opportunity to review your pre-filed direct and rebuttal testimony prior to today's hearing?
I have.
And do you have any corrections or changes to make to the pre-filed direct and rebuttal testimony that was submitted on your behalf?
I have reread it yesterday, and nothing stood out to me as being anything other than accurate.
Okay. And do you swear and affirm that the answers to the questions that were asked of you are true and correct to the best of your knowledge and belief?
I do. Yes.
At this time, on behalf of Thor Operating LLC and Keto Inc., we would offer the pre-filed direct and rebuttal testimony of Mark W. McCann.
No objections.
Hearing no objections, the reference testimony is admitted. Mr. Horst, do you have anything further for your witness, or do you tender him for cross?
Sorry, I tended the witness for cross-examination. My apologies.
Thank you. A formality. Mr. Marsh, you may proceed.
Thank you. Good morning, Mr. McCann.
Good morning.
Mr. McCann, looking through your testimony, it looks like there's 4 different companies that you mentioned between Keto Inc., Kansas Production Company, McCann Field Services, and Stellar Field Services. Do you own each of those companies?
No,
Which companies do you not own?
I do not own McCann Field Services.
Okay. Who does own McCann Field Services?
Mr. Getz owns it.
When did Mr. Getz begin owning McCann Field Services?
May the 20th of 2023.
Okay. Before May 20th, 2023, did you own McCann Field Services?
Yes, I did.
Okay. Do employees for those companies perform work for your other companies?
Currently or prior to 2023?
Not necessarily currently, but in the past.
Yes.
Okay. Do you have any other companies that operate leases or provide oil field services?
Yes.
What are those companies?
The Harland Oil Company, Vested Petroleum Incorporated, Castella Incorporated, Tricone Industries LLC, and Liberty Hill Oil Company.
And Keto was a company that previously or formerly operated your leases in Kansas, correct?
Formerly operated the leases that belong to Kansas Production Company.
Okay. And you're the sole owner of Kansas Production Company?
I am.
Okay. And Keto's license was revoked by the commission on February 9th, 2023, correct?
I don't have that date in front of me, but I believe that's correct.
Okay. When were Keto's leases shut in?
I don't know the exact date off the top of my head, but I was in contact with Mr. Horst, and the day he said it's time to shut in, we shut in that very day. However, I do recall a few of the leases, we couldn't get them all shut in one day, the lack of personnel, but most were shut in that day and the rest were shut in the following morning.
And in your testimony, you state that Mr. Getz had never been an employee of Keto Inc., correct?
That is correct.
But he has previously worked on Keto's leases, correct?
He worked on those leases. Keto has no leases. Keto was the operator of certain leases. So
Right. But
Mr.
okay, so Kansas Production Company's leases did
that
Mr.
I think that would be more accurate.
Okay. Um, and Kansas Production Company is the owner of the working interest of the wells you're wishing to transfer to Thor, correct?
That Keto is wishing to transfer, yes.
Okay. And Thor does not have any working interest in the leases, correct?
That is correct.
So then Thor would just be operating the wells on Kansas Production Company's behalf?
As the operator, the required licensed operator, and yes, as a contractor for Kansas Production Company.
And that's reflected in the operating agreement, correct?
I believe so. I haven't read that operating agreement for recently.
Okay. I'm going to pull up the operating agreement. I think it's attached to Ryan Hoffman's testimony as Exhibit RH1. And Mr. McCann, can you see that operating agreement?
It could be a little larger. It would be helpful.
Okay. Was that better?
Yes.
Okay. And this is an operating agreement between Thor Operating LLC and Kansas Production Company, Inc.
That is correct.
And paragraph 2 of that agreement says the interest of the parties and all costs and liabilities incurred in operations under this agreement shall be borne and paid as set forth in Exhibit B attached here too. Did I read that correctly?
Yes.
And in Exhibit B, it just has Kansas Production Company as the sole working interest owner.
I'm not seeing Exhibit B.
Okay, well, we'll scroll down to it.
But that would be correct. Kansas Production Company is the owner of the working interest of the leases.
Okay.
Yes, I see it now. That's correct.
Okay. So then Kansas Production Company would be responsible for paying all costs and liabilities incurred in operations of these leases.
That would be correct.
Go to page 2 of 56 of Exhibit RH1. Looking under paragraph 8, here it says payments and accounting. Operators shall promptly pay and discharge expenses incurred in the development and operation of the leases pursuant to this agreement, and shall charge each of the parties hereto with their respective proportionate shares of the expense. Operators shall keep accurate records showing expenses incurred and charges and credits made and received. Did I read that correctly?
Yes.
Scrolling down to page 3 of 56, regarding limitation of expenditures, it says without the consent of all parties, no well shall be drilled, deepened, reworked, or plugged back where the reasonably estimated cost thereof is in excess of the sum of $5,000. Did I read that correctly?
That's correct.
Okay. Mr. McCann, when did you approach Mr. Getz about operating Kansas Production Company's wells?
We've talked about him forming a business and being a contractor from my various businesses for the last 3 or 4 years. If we could go back to the last screen, I hate to do this, but well, never mind. I'll discuss it with Mr. Horst. Go ahead, please.
Okay. And you, Mr. Getz, both identified specific wells for Mr. Getz to operate. Is that correct?
Yeah, the T1 reflects the wells that Thor has agreed to operate.
And those wells, specific wells, you determined to have less compliance issues than other wells that weren't being transferred?
Not precisely, but these wells were equipped to operate, and these wells were currently in compliance, to my understanding. I don't know about a one-to-one comparison, but in general, that I would say these wells, yes.
I'm looking at page 6 of your testimony, lines 13 through 18. Question, did you discuss with Mr. Getz which wells Keto would transfer to Thor on each of the leases? And if so, summarize the substance of those discussions. Answer, in light of the non-renewal of Keto's license, Mr. Getz and I agreed that it would be best to identify and transfer those wells on the 8 leases which presented limited risk involving regulatory compliance issues. Did I read that correctly?
You did.
And your company also helped Mr. Getz set up a Kohler account, correct?
I'm not that familiar with Kohler. We have had trouble along the way. Keto does not have access, and my company helping set that up. I have no direct involvement with that.
Okay. Did you have a former employee named Chris Williams?
Yes, for a brief period.
Okay. Were you present for Denise Klug's testimony earlier today?
Yes.
Okay. I'd like to share exhibit DK1. This email is dated March 23rd, 2023. It says from Mark McCann or mccann.companies@outlook.com. It says Denise attaches the master electronic filing certification for Thor Operating LLC. And the signature is Christopher A. Williams. Did I read that correctly?
You read it correctly.
And in your testimony, you state that Keto has not operated any wells after February 9th, 2023, correct?
If that's the date that when we were told to shut down, yes, we would never operate without, with not being in compliance and being told to shut down, we would never purposely continue to operate.
Although earlier in your testimony, you did say that there were some wells that were shut down the morning after, correct?
As soon as possible, once we were given the shutdown, we shut down.
Okay. So from whenever you shut the wells in to October 23rd, 2023, when the commission issued its shut-in order, Thor would have been the operator of the wells, correct?
Could you repeat that, please?
So from the time that you shut in wells after the commission's final order to October 3rd, 2023, when the commission issued a shut-in order, the wells would have been operated by Thor Operating, correct?
After Thor obtained its license, we followed the regulations as instructed, and we filed our T1s. And also, as part of that, we had to install new signs on the leases and give notice to the landowners. Those steps were followed by Keto to transfer to Thor. I'm not exactly sure of the dates, but the point is we shut down when we were told to, And then after we made these other steps and transferred to Thor, it was my full and complete understanding we had satisfied the requirements and that Thor could then operate.
So Thor would have been the operator of the wells after Keto shut them in, correct?
Not the next day, but after those other steps, the licensing, the T1s, and the tank battery signs and the landowner notifications were all accomplished within their specified timeframes.
Now, as part of this, these dockets, there was some discovery done that included text messages between you and Thor, correct?
Yes.
Okay. I'm going to pull up what's been attached to Mr. Hoffman's testimony as Exhibit RH2. I think it's RH2. Still trying to get there. Okay. And can you see these messages or Exhibit RH2 on your screen?
Yes.
Okay. And these are messages from you to Thor, correct?
I believe so.
Okay. And on page 1 of our Exhibit RH2, a message from you to Thor says, "We are pulling Sears number 2 today. The pump will be on the back of the red Ford. We need to determine why it failed. It never made any oil since last pulling. Possible pump issue." Did I read that correctly?
Yes.
Scrolling down to, I believe it's page 3 of 16. Has a date, Sunday, June 11th at 6:31 p.m. Tomorrow, let's focus on getting the Morton fixed and running, and also changing the dearmament pulley, as in parentheses M-4, and on the speed up of the equity, after equity, if there's time to install the part that Steve welded and confirm the rig ID working 100%. Did I read that correctly?
Yes.
On page 4 of 16, it looks like it's a message from Thor to you. And at the top, it says M3 is hitting on top. You want it slower. Did I read that correctly?
Yes.
Okay. Scrolling down to page 7 of 16. You sent a message, okay, had to shut Morton down, tank leak and swivel leaking. Did I read that correctly?
Yes.
On page 9 of 16, there's a message from you to Thor that says head to Morton, power off at the pole with the meter. And then a second message says on Sears shut off number 2, check 30 or 30 and 28 and M1. Drain all gas and some oil on M1. Did I read those messages correctly?
Yes.
And what was the purpose of selecting some of the messages on the side?
I don't know anything about that.
Okay. Is this a complete record of text messages?
We tried our best to comply with what was requested. We sent everything that we had available.
Okay. Moving on to page 12 of 16. It says the packing on the Culver, McFarland, and Sears are all leaking and cannot be tightened anymore. Did I read that correctly?
Yes.
And then lastly, on page 14 of 16, it says on Thursday at 1 o'clock, you need to meet at the Sears with Thad to MIT test well 27 and also A-2. Then on Friday, dearmament 6 at 1 o'clock. All 3 of these are nitrogen tests. Did I read that correctly?
Yes, you did.
And at the time that the commission revoked Quito's license, there were 141 wells on the license, correct?
I don't know that number exactly, but approximately yes.
Okay. And Thor was only seeking to transfer 47 wells to Thor.
I believe that's correct.
And there have not been any other T1 forms that have been filed to transfer wells from Quito to other operators, correct?
No,
In your testimony, you state the revenue needed to plug wells comes from production revenue, correct?
yes.
How much revenue is generated from your production in Kansas?
That would vary month to month, day to day. It would be influenced by the price of oil and the weather and other production challenges.
Can you give an average?
It would just be a guess.
Okay. How much does it cost to plug a well in Kansas?
Well, we have all the equipment necessary to do that ourselves, so we could probably plug a well for a couple $1,000s, I'm guessing.
I'm almost done, so thank you for your patience. On page 18, lines 10 through 3 of your testimony, you state that Quito did not transfer the remaining wells to Thor because docket number 24-3001 had been opened, creating doubt as to whether the wells could be transferred to Thor. Is that correct?
That was a while ago, but I believe that's correct.
Okay. So then you would have been aware of staff's motion in docket 24-3001.
I'm not familiar with what you're quoting.
Well, basically, I mean, your testimony states that you would have had knowledge that staff filed a motion in docket 24-3001, correct?
I'm not following with all these dockets and numbers, and
Okay.
I'm not tracking with that. Was this something relative to Quito or relative to Thor?
I guess it'd been relative to Thor. So you know what? I'll just ask Mr. Getz, so we can cover that with him. Thank you. I don't have any further questions.
All right. Are there any commissioner questions for this witness? Commissioner Keither?
No, thank you.
And I actually have no questions for you as well, Mr. McCann. So with that, Mr. Horst, do you have any redirect?
No, I don't think I have any redirect from this witness.
All right. Thank you. Well, with that, Mr. McCann, we have reached the conclusion of your testimony. We thank you for your testimony today, and you may step down. Mr. Horst, you may call your second witness.
Call Scott Joe Getz.
Yes.
And if we could have someone change the name to Mr. Getz's name. All right. Mr. Getz, I'm going to swear you in. If you would please raise your right hand for me. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
All right. Thank you. Please proceed, Mr. Horst.
Are you the same Scott Joe Getz who filed pre-filed direct and rebuttal testimony in these dockets on June 7, 2024?
Yes.
And Mr. Getz, have you had an opportunity prior to today's hearing to review your pre-filed direct and rebuttal testimony?
I looked over them briefly yesterday.
Okay. After review of your pre-filed direct and rebuttal testimony, do you have any corrections or changes that you'd like to make?
No, not this time.
Do you swear or affirm that the answers to the questions that were asked in your pre-filed testimony are true and correct to the best of your knowledge and belief?
I do.
Okay. And do you request that excuse me, I got lost. Okay. I believe at this point then the Mr. Getz would offer on behalf of himself, Thor, and Keto his pre-filed direct and rebuttal testimony.
No objections.
Hearing no objections, the reference testimonies will be admitted. Mr. Horst,
We
anything
would
further?
tender the witness then for cross-examination.
Thank you. Mr. Marsh, do you have examination for this witness?
Yes, thank you. Good morning, Mr. Getz.
Good morning.
Mr. Getz, you formed Thor Operating LLC on February 10th, 2023, correct?
Yes, sir.
And that was the day after Keto's license was revoked by the commission by final order and docket 22 CONS 3115 CMSC, correct?
Yes.
And in your testimony, you state that the purpose of forming Thor was to operate the leases previously operated by Keto, correct?
Yes.
So if Mr. McCann had never asked you to operate the leases, Thor would not have been formed, correct?
Well, I can't really say that. We had discussed doing different operations prior to that.
But would Thor have been formed on February 10th if Mr. McCann had not asked you about it?
Did it speed the process up? I'd say it did.
In your testimony, you state that you've never been an employee of Keto Inc., correct?
That's correct.
But you had previously signed off as a pumper for Keto?
I worked from McCann Field Services briefly, and then I did contract work for him.
Okay. But my question was, you previously signed off as a pumper for Keto Inc., correct?
Yes.
And you've worked on Keto's leases or Kansas Production Company's leases in Kansas, is that correct?
Yes.
And I believe in your testimony, you state that you were a pumper and a rustabout for McCann Field Services.
Mm-hmm.
All right. Is that a yes?
Yes. Yes.
Sorry, since we have a record, we have to have affirmative yes or no answers. That's the
I
only reason.
understand. I apologize.
And at the time that you're working for McCann Field Services, was it owned by Mr. McCann?
Yes.
And I believe you stated that your employment with McCann Field Services ended in October 2022. Is that correct?
Right in that time.
Okay. Why did your services with McCann Field Services end?
I was just doing different projects at that time.
Okay. So then what led you to want to own or control or McCann Field Services later?
Well, we had different business dealings, and I don't know. That was just in our relationship.
Okay. And as a pumper and a rustabout, would you perform services such as pulling wells?
Yes.
Would you equip wells and place them in production?
Yes.
Would you install oil and gas lease infrastructure?
Yes.
And would you repair and maintain equipment on the leases?
Yes.
Okay. And Mr. McCann's testimony mentions that you also perform work for his company, Stellar Field Services. Is that correct?
Correct.
What kind of work do you perform for Stellar Field Services?
All the ones you just listed.
Okay. Why did you not include your work for Stellar Field Services in your background and experience in your testimony?
I worked for several different companies as a contractor, and I just didn't list them all the companies that I do work for at the present time.
Okay. Does your work for Stellar Field Services include work on Kansas Production Company's leases?
Yes.
And I believe as part of the discovery process, there were invoices attached to one of the responses. I'm going to pull up KCC Cross 2, or I think it's KCC Cross 1, if I may. Does your work for Stellar Field Services, or does Thor conduct work for other companies other than like Kansas Production Company and Stellar Field Services?
Yes.
Which companies are those?
MJ Gets Bonding out of Oklahoma.
I'm pulling up what's been identified as KCC Cross 1. And I'm just going to go with the top invoice, which is page 69 of 80. Mr. Getz, can you see that invoice?
Yes, can.
Okay. And this is from Thor operating to Stellar Field Services.
Okay.
It doesn't say where what work was or where the work was done that was invoiced, but would this work have been done on the leases formerly operated by Keto?
I can't say that. I don't know for sure.
Okay.
Not
But
necessarily.
okay. What's at least one of the invoices include work for the leases in Kansas?
I can't say. Let me see here. I can't say for sure.
Okay.
I mean, we do a lot of work in Oklahoma too.
Gotcha. Do you have any way of keeping track of where you've done work and what invoices or what work that's been done?
I could, yes.
But not with these specific invoices?
But no, I don't have anything with me now that would show
Okay.
that.
In your testimony, you state that you, Mr. McCann, selected specific wells to transfer that would limit Thor's exposure to regulatory issues. Is that correct?
That's correct.
Did you have an idea of which wells would have less regulatory issues based on your work at Keto/Kansas Production Company's leases?
Not really.
So were you just going off of Mr. McCann's word then?
So. That's just what we had agreed upon. But we went out in the field and looked and talked and discussed it.
So you physically inspected the wells and then determined which ones you wanted to transfer to Thor's license?
Not every one of them. Ones that were in production at that time.
So you were wells that were in production considered to have limited regulatory issues, then more desirable to transfer?
Well, those wells were shut down. The wells that were shut down, I wasn't. We didn't transfer those at that time. We just.
So you only transfer the wells that were in production?
Yes.
Okay. And these wells were in production when the T1s were filed?
Yes.
You were aware that staff opposed the transfer of wells to Thor's license, correct?
Yes.
Okay. But you continue to operate the wells even after staff filed its motion and docket 24-3001?
No. Once we found out about the fine, then we shut everything down.
Right. I'm talking about before the fine, though. Staff filed a motion on July.
All the wells were shut down at that time. All the wells were shut down.
Right, but so staff filed a motion at docket 24-3001 on July 3rd, 2023, correct?
Ask that one more time.
Staff filed a motion regarding Thor's license and the T1s between Keto and Thor on July 3rd, 2023, correct?
Okay. Yes,
And
I suppose.
Thor continued operating the wells even after that motion was filed, correct?
No, I don't.
Okay,
You're saying in July, correct?
correct.
The wells were not in production, no.
Okay.
Not to my knowledge. Once we got notice that the wells were supposed to be shut down, we shut them down.
Correct. But that was after the commission issued a shut-in order, right?
Yes.
Okay. Because I'm sharing a docket page for docket 24-CONS-3001-CHS or CSHO. Is that correct?
Yes.
And it says motion for the designation of presiding officer and scheduling of pre-hearing conference, and that was filed on July 3rd, 2023, correct?
That's what it says.
Okay.
Mr. Marsh, you may need to zoom. These documents are pretty small on our
Sure.
Zoom screen.
And I will, Chair French. The top of this document says motion for designation of presiding officer and scheduling a pre-hearing conference. Is that correct?
Yes.
Okay. I'm just going to scroll down to the bottom of the document. At the end of the document on page 3, it says staff's position is that operator's license should be revoked and operators request to transfer the wells from the Appleby, DeArmond, Flossie White, McFarland DeLong, Morton, Sears, Wall, and Williamson leases onto its license should be denied. Did I read that correctly?
Yes.
So you're saying that Thor shut in the wells after staff filed its motion on July 3rd, correct?
I don't know for sure.
Okay. I was just curious because staff's field report where it documented the wells in operation was July 18th, 2023, which would have been after staff filed this motion. Do you see the field report that I pulled up?
Yeah, yes.
And on the inspection date, it says 7/18/2023.
Yeah. I never received that letter.
You never received what?
Any of this, what you just showed,
The field report or the motion?
the motion.
Okay. Right. Then I'm going to go back to your testimony. And page 22. Can you see page 22 of your testimony?
Yes, I can.
Okay. I'm going to specifically refer to line 6 through, I think, 10. Question on July 3rd, 2023, commission staff filed its motion for the designation of a presiding officer and the scheduling of pre-hearing conference. And it says, was Thor notified at any time after the filing that motion to cease operation of the injection wells transferred by Keto to Thor? The answer is no. Did I read that correctly?
Yes.
So you would have been aware of staff's motion from July 3rd then, correct?
No, I was not aware of it at the time.
but you included it in your testimony?
Yes, I'm just not sure on it. I can't say for sure.
And were you just operating the producing wells, or were you also operating injection wells?
The injection wells were also being operated, yes.
Were you operating the leases yourself, or did you have others working for you?
I was mainly doing it myself.
Okay. And as Thor operating, did your activities on the lease, would it have included pulling wells?
Correct. Yes,
And,
yes, it did.
and would have included equipping wells and placing them in production?
Yes,
Would it have included installing oil and gas lease infrastructure?
yes, yes,
And would it have included repairing and maintaining equipment on the leases?
yes,
So basically, the same things that you were doing as a pumper for McCann Field Services, correct?
yes.
In your testimony, you state that Thor initially attempted to submit a $30,000 irrevocable letter of credit, correct?
Yes,
And you would have been familiar with the commission's instructions for letters of credit, correct?
yes. I mean, yes. To the best of my knowledge, I was trying to do it the best I could, yes, and as accurate as I could.
Okay. Were you present whenever Ms. Boris testified earlier?
Yes, I was.
Um, I'm pulling up what's previously been admitted as Exhibit NB-1. I'm looking at page 2 of 3. At the top, it says instructions for letter of credit, and it says standard letter. The attached sample letter of credit must be followed. Did I read that correctly?
Yes, yes, sir.
And I'm going to scroll down. So this is the sample irrevocable letter of credit, correct?
Yes,
And then attaches Exhibit NB2 is a letter of credit that you submitted, correct?
yes.
So why does the letter of credit you submitted not look anything like the sample letter of credit?
I just didn't understand.
So you didn't understand that the attached sample letter of credit must be followed?
No, I didn't understand it correctly.
Do you ever call Ms. Boris to see if the letter of credit was acceptable or not?
I thought it was acceptable. I thought that we did everything appropriately.
So you did not call?
Did I what now?
You did not call Ms. Boris regarding the letter of credit?
I don't remember if I did or not.
I believe your testimony states that Thor is willing to pay a non-refundable fee of $1,800 to replace the letter of credit, correct?
Yes,
But Thor has not submitted that payment yet, correct?
correct.
Where's the money for the $1,800 cash option coming from?
It will come from um, from Mr. McCann.
Now, are you familiar with Mr. Troy Russell's testimony?
Yes,
And you're familiar with the compliance issues that Mr. Russell has referenced in his testimony?
Yes.
What funds does Thor have to address the compliance issues documented in his testimony?
Ask one more time.
What funds does Thor have available to address the compliance issues documented in Mr. Russell's testimony?
What funds necessary? Well, at this time, are you asking how much money I have in the bank? Is that what you're asking?
More or less, I mean, would it be for Thor's funds that are being used to address compliance
Yes,
issues?
it'd be
Would it
Thor's funds, yes.
or would it be Mr. McCann's
No,
funds?
it'd be Thor's.
I'm going to pull up what's been previously marked as KCC Cross 2. I'm going to go to page 28 of 44. Mr. Getz, this is a checking account inquiry for a bank account for Thor Operating LLC, correct?
Yes.
And the current balance says $32.07. Is that correct?
Okay.
So you're saying,
Go ahead.
so are you saying that Thor can address all the compliance issues addressed in Mr. Russell's testimony?
I have other money available.
From where?
From my other company.
Okay. Doesn't the operating agreement basically say that any expenses that Thor incurs will be charged to Kansas Production Company?
It does.
Okay. Would you agree with me that a majority of the wells are not in compliance with 82.3.111 at this point?
I cannot agree with that. No, I mean,
Why not?
I would say that they're in compliance.
I mean, the reason, so are they in operation?
No, nothing's
Okay.
in operation.
And they were shut in on October 3rd, 2023, correct?
I believe so. Like, I can't say for sure.
So you don't know when you shut in the wells?
And that's approximate date.
Okay. And that is over a year ago, correct?
Yes.
Did Mr. McCann just show you something?
No.
Sorry, I just saw you look over at his direction and nod up and down, so I was confused what was going on there.
No.
Okay. So if the well's been shut in longer than 365 days, then they would no longer qualify under 111E, correct?
If that was the case, I assume so. I don't know.
Okay. I mean, your testimony, you did state that you were familiar with KAR 82-3-111, correct?
Vaguely.
Okay. I believe in your testimony, you state that the annual fluid injection report for the Sears number 27 was not completed and filed, correct?
I believe so.
And that form still has not been filed?
I don't know. I don't have that information in front of me.
I believe that's all my questions. Thank you.
Thank you. We will now move to commissioner questions. Commissioner Keither, do you have any questions?
Not at this time. There's a lot to digest here.
I apologize. Could we take a bathroom break? Is that possible?
Let's see. Well, let's, I don't think I'll have a lot for you. So let's keep going for just another few minutes and then, I think we'll be close. I've just got a few questions. So first, On the operating agreement, I know you discussed in your testimony that this was a plan that you worked on with Mr. McCann to take on some of his wells. Does Thor have operating agreements with other leaseholders?
No,
Okay, so these operating
not at
agreements
this.
are,
I'm sorry.
the operating agreement between you and Kansas Production, who prepared that?
Uh, I had an attorney do it. I think it was Mr. Horst, is the one that,
And it was you that initiated that?
yes.
Okay. Did Mr. McCann have any involvement in negotiating that agreement?
We both did.
So so essentially you and Mr. McCann worked with Mr. Horst to draw that up.
Yes.
Okay. Um, did either of you have a separate attorney look at it?
I didn't.
All right. I think that's all I have on that. The only other thing I want to ask you about is the letter of credit you provided. Can you walk me through the process you followed to get that letter of credit?
Um, I had some help with it. I wasn't real familiar with the process on how to do this. I was just kind of learning this, and so I did use Mark's office help to do this.
So they help fill out the forms. Did you have to provide information relating to assets to obtain that letter of credit?
Yes.
And generally, what assets did you list to get the letter of credit?
I believe there was a polling unit. Is how I did it.
Just a single polling unit,
Yes.
and that belonged to Thor?
Yes. No, well, it belonged to me personally.
You personally, okay. I don't believe I have anything else. Mr. Horst, do you have any redirect?
Just one brief question. Mr. Getz, the wells on these 8 leases were sealed by commission order in October of 2023. Do you recall that date?
Yes.
Or that
Yes.
event?
Yeah. Yes.
And they have remained sealed since that time?
Yes.
Okay. So do you understand that KAR 823111 relates to wells that have been upon which operations have ceased, and which are subject to the necessity to file temporary abandonment applications? Are you familiar with the regulation? I'll put it that way.
Vaguely.
Okay. But the cause of the cessation of operation is the action that the state took to seal the wells.
Yes.
Correct. Okay. I think that's all the questions I have of Mr. Getz.
All right, Mr. Marsh, are you going to have any recross? Okay, very good. Then I think we have completed this witness. Mr. Getz, you may step down, and we will then go ahead and move forward. I don't think we'll need a break, Mr. Getz. You can take a break now if you want. We won't need any more testimony, but we do thank you for your testimony.
Thank you.
If everybody else is ready to move forward, we will move forward to closing statements, and we will begin with Mr. Horst.
Thank you, Commissioner French. As the evidence and testimony in this case demonstrates, although there is communication and contact between Mark McCann and Keto Inc. and Scott Getz and Thor, KSA 55155 simply does not prohibit that type of contact. It does not render Mr. Getz or Thor ineligible to obtain and maintain an operator's license. It does not prohibit the transfer of the wells from Keto to Thor. For that reason, the penalty order issued in docket number 3086, I believe it is. Yeah, 24 CONS 3086 should be denied. And the commission staff should be directed to transfer the wells from Keto to Thor. With respect to the penalty that commission staff seeks in 24 CONS 3072, the evidence is clear that Keto's failure is not a failure to comply with 82.3.120. That regulation simply mandates that an operator continue to renew its license. Keto attempted to do so, but its effort to do so was denied by the commission. And for that reason, Keto has not violated 82.3.120, and the penalty in that docket should be denied as well, and that matter dismissed. Thank you.
Thank you, Mr. Horst. Mr. Marsh.
Thank you. Well, as I stated in my opening, we have 3 separate dockets, and there's issues that are specific to each of those dockets. Starting off with docket 24-3001, we have 2 issues of whether Thor should continue to be a licensed operator in the state of Kansas, and the second issue of whether staff should process the T1 forms. I think if you look at 55-155C1, it says no application or renewal application shall be approved until the applicant has provided sufficient information as required by the commission for purposes of identification. I don't think Thor has done a sufficient job of showing that it's any different than Keto. If you look at, it's as simple as following the money. Kansas Production Inc., which is owned by Mark McCann, finances Thor operating. Thor hasn't shown that it has the capital to address the issues that staff has already found on the leases. Kansas Production Company is basically paying for the salary expenses or losses of Thor, and that's reflected in the operating agreements. You also have just evidence that there's other evidence that indicates that this transaction wasn't made at arm's length from the communication of the text messages from between Mark McCann and Thor. Mr. McCann's employees helping Thor submit the master electronic filing certification for Kohler. It's just kind of an endless list here. Moving on to docket 24-3072. In my opening, I said the issue is as simple as the issue is, are there unplugged wells on Keto's license? And I think the answer there is pretty simple. There are unplugged wells that are on Keto's license. That was reflected in Ms. Bors's testimony, both I think pre-filed and during live testimony today. And then in docket 24-3086, the issue is whether Keto should be penalized for operating wells after its license was revoked, or if Thor should be penalized for operating wells that weren't on its license. And I think there's ample evidence that shows that Keto has been operating these leases. I mean, Mr. Getz testified that the wells were in operation whenever were transferred to him. Mr. McCann stated that the wells were not shut in necessarily the day that the commission issued its order revoking the license. Some were shut, maybe a day after. You also have production records from the Sears lease that indicates constant production across the months where the wells were supposed to be shut in. I believe that was reflected in Mr. Russell's testimony. And then when it comes to, Thor operating wells that aren't on its license, they never called to see if the T1s have been processed, never provided sufficient letter of credit. Even after staff filed its motion on July 3rd, 2023 and docket 243001, in that motion, staff basically put Thor on notice, hey, we don't approve of these T1s being transferred and we want the commission's input on before those wells are transferred. Thor continued to operate after that motion was filed, and that's when staff found Thor operating, or the Sears 30 well in operation is still on Keto's license, but is apparently being operated by Thor. But either way, I think there's enough information and evidence before the commission to assess a penalty to both companies. And I think the recommended penalty was $25,000 each. I'll leave that up to the commission to decide what's appropriate. But other than that, I don't think I have anything else. Thank you for your time today.
All right. Thank you, Mr. Marsh. Now just for post-hearing issues, before we conclude, I wanted to see if the parties had anything else the commission needed to take up, including whether there would be filing of post-hearing briefs. My understanding from the pre-hearing conference is that the parties did not anticipate filing post-hearing briefs. I know we have a pending a motion for summary judgment in a response, and there's quite a bit of briefing within that. Is there any need for additional briefing from the parties?
I'll kind of leave that up to you, Chair French. It seemed like, earlier today that you were kind of thinking that maybe that would be needed. If you think it's needed, then staff's happy to do so.
My thinking right now is that we've got a good record, and we should be able to reach a conclusion of the legal issues with what we have, but the commission will confer with our counsel, and if we think additional briefing is needed, then we'll be in contact with you. Mr. Horst, I did see you open your mouth a little bit there. Did you? I hope I didn't cut you off.
No, you didn't. We'll do whatever the commission directs.
Okay, very good. Any other final issues we need to take up before we conclude the hearing? All right. Hearing none, this does conclude our hearing in this docket. At this time, we will close the record and adjourn. We thank you all for your participation. Have a good day.
Thank you, you too.